We're here today on behalf of the Virginia Supreme Court Historical Commission to interview and do an oral history of Senior Justice Harry L. Carrico. Justice Carrico was the longest-serving member of the Virginia Supreme Court, having served 42 years when he retired in 2003, and was also the longest-serving Chief Justice of Virginia, having served in that position for 22 years at the time of his retirement. Chief Justice Carrico, welcome this morning, and are so happy that you were able to be with us. And I'm going to ask you some questions all about coming to the Supreme Court, about the Supreme Court, about your memories, about what was happening, so that we have these for posterity, for people to learn about what the court was like, both when you began on the court and when you retired from the court in 2003, and of course beyond to today. When were you first elected to the Virginia Supreme Court, and how old were you?
Well, I was sworn in on January 30th, 1961, at age 44.
At that point in time, were you among the younger members of the court, the older members?
Younger. I was the youngest in 100 years.
I see. So most of your colleagues were much older than you were?
Well, Chief Justice Anson was not that much older, nor Chief Justice Smead, but the other four were considerably older.
And what was your legal and judicial experience before you were sworn into the Supreme Court? What kind of practice did you have? Were you a judge before then?
Well, I got in the judging business pretty early in life, within a year of my graduating from law school. I was appointed to what is now the General District Court. Back in those days, we had both the work of the General District Court, we also had the work of the Juvenile Domestic Relations District Court in one court. And that was in 1943, and I was as green as grass.
What jurisdiction was that? What jurisdiction? What county?
Fairfax. And some of the old lawyers gave me a hard time for a while, but I stayed in that 8 years. Then I went in private practice for 5 years, and I was never really happy in those 5 years. I hadn't known anything before I started practice except being a judge. And the opportunity came along after 5 years, and I had a change in my family situation because of my wife's health. They created an additional circuit court judge in Fairfax, and I was appointed to that in 1956, and stayed there for 5 years, and then came up here in 1961.
In those years in Fairfax, we all now in the 21st century think of Fairfax as this huge metropolitan county with high-rise and over 1 million people. What was Fairfax like when you first started there?
Well, the Fairfax Bar Association met to endorse one of the two candidates. The vote was 8-7.
And that was the entire
in my favor. Well, there were 2 members away in the service, which made 17. The total membership of Fairfax Bar Association in 1943 was 17 members.
And now there are about 2,500 members, as I understand it.
Well, it was interesting. We had one member who did not practice at the courthouse. He had a little office on Route 7, just west of Tyson's Corner. And my opponents thought that he ought not to count. Now, he was a member of the Fairfax Bar Association, but they thought his vote should not be counted because he wasn't practicing at the courthouse.
Very, very narrow interpretation of the rules.
Yeah.
When you were going back to those early days, when you were a judge in Fairfax in the 40s and 50s, did you sit in one courthouse? Did you have to travel at all, or was it just mainly in the Fairfax courthouse?
Well, in the first job, that was just Fairfax courthouse. But then when I went to the circuit court, the circuit was Fairfax, Alexandra, and Prince William.
And how many judges of the circuit court were there?
3.
There were 3 to cover Fairfax, Alexandria, and Prince William,
Right.
and there were probably about 30 that
Yep.
cover that same space today. How did you just go from place to place, just in your car, or were there any interesting ways that you had to get there?
No, I drove.
Well, any times you had to take other transportation to get there, to get to the different courthouses?
You're talking about the horse?
Yes. I heard about the horse.
That was in the snowstorm. That's when I was on the circuit court, and we had this terrible snowstorm on a Sunday, and it tied up everything for a week. Well, I needed to get the papers in the case that I was going to try the following Monday, and I lived 5 miles from the courthouse, and I couldn't get out to the main road. So I saddled up my horse and rode it to the courthouse, tied her up to the rail out in back of where the judges' chambers used to be, and went and got my papers and came home.
You wonder if more people might not want to do that today when traffic gets really bad in Northern Virginia.
No.
When you decided to run for the Supreme Court of Virginia, do you recall who else was interested in that position? Was in terms of who your opposition was, who your opponents were?
Well, what happened when the vacancy was known? Armistead Booth, who was the state senator from Alexandria at that time, came to every circuit court judge in Northern Virginia. You know, Northern Virginia had never had a member on the Supreme Court before. And he came to every member on the circuit court in Arlington, Alexandria, Fairfax, and Prince William, trying to get one of us to say that we would go for it. We all said no. Judge McCarthy, who, when I started practicing, was the single judge in Arlington, Alexandria, Fairfax, and Prince William. He had tried 3 times to go on the Supreme Court and was turned down each time. And we didn't want to get the treatment that he got. Well, then someone called from Richmond, wanted to come see me. And he said he had reason to believe that if Northern Virginia was ever going to get a judge on the Supreme Court of Virginia, it would be under this governor, and that was J. Lindsay Almond, Jr. For every reason I could think of for not doing it, he had an answer to. And I said, well, give me 24 hours to think it over. First thing I did was call all the other judges and tell them what I had been told. And I told each one of them, if you're interested, I'll support you. Now, Judge McCarthy just laughed at me. He says, okay, if you want to get mixed up in that thing, you go ahead and get it mixed up. Well, before the 24 hours were up, my friends had gone to work. It got out that I was interested. And I mean, it had gotten to the point where if I said, no, I'm not, I would have embarrassed my friends. So I said, well, I'll stay in it. If I lose, I lose, I lose. But things began clicking, and it just was amazing how the thing went. And, you know, back in those days, the Virginia Bar Association's recommendations were very important. They had a large committee that met first. There were 30-some names considered by that committee. Then they had a select committee that reduced the number to 3. And one of the fortunate things was that the immediate past president of the Virginia Bar Association was Bob McCandlish. He was a good friend of mine.
From Fairfax.
And he called me at 3 o'clock and said, we've just left the governor's office, and your name was one of the 3 names submitted. I said, well, Bob, does that mean I got a third of a chance? He says, you got better than a third of a chance. I got the opportunity to tell the governor that you get on the list before the others did. They had to take several ballots to get them on the list. But he says, nothing to do but sit back and wait. And as you know, there's a lot of waiting to be a judge. Well, the very next morning, I was in my office getting ready to go down to court. And the phone rang. And it was Senator Charlie Fenwick from Arlington County, saying that the governor had given him the honor of telling me that he was going to appoint me to the Supreme Court, but that I couldn't tell anybody about it until 11 o'clock. I said, well, can I tell my wife? He says, yes, your wife, but no one else. So I hung up, called my wife, and remember Eleanor Chesley?
Yes.
Who was the judge's secretary?
Yes.
She came in to bring me the docket. As I was hanging up, she says, you know something, don't you? I said, no. Well, and Charlie Fenwick impressed upon me. He said, you will embarrass the governor if you let it out before 11 o'clock. I said, no, I don't know anything. So sit down. And then I went on down to get with the other two judges. And I know she had told them. And I wonder till this day whether I did right. I mean, we were close friends. And I told them, no, I didn't know anything. I had given my word I would not tell it. On the other hand, we were such close friends, I can see where they felt bad that I didn't tell them. And I still worry about whether I did the right thing or not.
To this day. Well, that's a fascinating story. I didn't realize you were the first from Northern Virginia.
Yeah. But I went on and tried my case.
Of course.
And then at 11 o'clock, Ellery came in with a note that says, there's a phone call I think you should take.
The official phone call.
Yeah.
And then you could tell everybody.
Yeah.
Oh, that's fascinating. Do you remember whose spot you took, whose seat you took, who the justice was who preceded you?
Willis Miller.
But he was not from Northern Virginia.
From here in Richmond.
Well, so. And then was this during the time the legislature was not in session?
That's
so
right.
It was a governor's
Yes.
appointment then.
Mm-hmm.
And then you were sworn in on the 31st of January, did you say, of 2003? Excuse me, 1961. Is that correct?
January 30th.
30th. Now, when you started working on the case in Supreme Court, you moved down to Richmond, correct? You didn't stay.
No.
You stayed in Fairfax?
We stayed in Fairfax for 8.5 years, and we come down just for court. The members, only one member of the court was a resident of Richmond. The other 6, we stayed at the John Marshall Hotel. We usually stayed into the second week. The court holds it just for 1 week now. But we allowed an hour to a side, so we couldn't get as many cases tried as they can get these days.
An hour to a side for arguments.
Yeah. And we had 3 lawyers in the state who, whenever they came, they would spend the first 5 minutes saying how they couldn't tell us about their case in an hour.
An hour wasn't long enough?
It wasn't long enough.
They obviously didn't talk fast enough, and that's amazing. A lawyer now would love to have an hour to be able to argue his or her case before the Supreme Court or any appellate court. Can you think back in the years on the court to significant cases or cases that stand out among all others that you've decided? And obviously, you've decided hundreds, if not thousands, of cases that you felt either were personally significant or significant in the context of the jurisprudence of the Commonwealth of Virginia?
Well, not really. I decided some important cases, but I can't call any by name right now.
Do you remember any times during all the years that you were on the Supreme Court of Virginia, both as an Associate Justice and as Chief Justice, where you would hear a case or a case would come before you that your own personal feelings about the issue conflicted with where you believed the law required you to go? We see that as an issue quite frequently nowadays in cases.
Oh, I think occasionally, yes.
And how did you reconcile those issues that are challenges for judges all over the country today?
Well, I just gave up my personal feelings. But once I was satisfied what the law was, you have to give up your own personal feelings.
Did you have any particular judicial heroes or either in history or among your colleagues or mentors among your colleagues?
Well, John Marshall, I got to be affectionate of him very early in the game. In my freshman year at high school, they had an oratorical contest, which I won. And the prize was a little silhouette of John Marshall. So I got interested in him. He's always been my model, is today. Paul Brown, my senior circuit court judge in Fairfax, was one of my heroes. Arthur Sinclair, the second one, was. We had a wonderful relationship. We really did. They were two wonderful people and two wonderful judges.
So when you were on the circuit court of Fairfax, the other judges were Paul E. Brown, right?
Paul E. Brown.
And Arthur Sinclair.
Right. Mm-hmm.
Mm-hmm. That was a phenomenal court.
Yeah. Then later on, I became very friendly with Chief Justice Berger, and a wonderful relationship, and one that I prize very highly. And perhaps not to as great an extent, because they were two different people, a very fine relationship with Chief Justice Rehnquist. And able to do a number of things that he was helpful in. And he was the first Chief Justice to appoint a state court judge to a standing committee of the Judicial Conference of the United States. And I was one of the four that were on that, in that group.
Explain what the Judicial Conference of the United States is, because many people won't know what that is.
Well, it's composed of all the judges, and it's
the federal judges.
Yes, all the federal judges, and it's for the purpose of training and education and taking positions on matters that affect the judiciary. We have our own in Virginia of state judges, and it's there for that same purpose. The committee that I was appointed to was a state federal committee, and anything that came up before the Judicial Council of the United States that affected state judges came before that committee. So the state judges had an opportunity to have a say in what the position of the whole Judicial Council of the United States should be.
And there had never been that before Chief Justice Rehnquist made the decision to include state court judges.
And I served on it longer than any of the others, 9 years. I learned that last summer.
Oh, you didn't. Well, it's interesting that both Chief Justice Berger and Chief Justice Rehnquist, when they were on the U.S. Supreme Court, lived in Virginia. Of course, not only in Virginia, in Arlington. So they had, and I know both felt, from my understanding historically with Justice Berger and from personal knowledge from Chief Justice Rehnquist, that they both had great affection for the Commonwealth and for Arlington County.
Yeah, if I were at a meeting somewhere that Chief Justice Berger was, he put his arms around my shoulder and say, "This is my Chief Justice."
That had to be quite a compliment. Yeah. Who were the justices on the Supreme Court when you began? You mentioned Justice Sneed and Justice
John W.
Hanson.
Eccleston was Chief Justice. C. Vernon Spratley was next. Archibald Buchanan was next. Kenan Whittle was next. Then Judge Sneed, then Judge Hanson, and then me.
And And during the course of time that you were on the Supreme Court, that 42 years, you must have noticed some significant changes in connection with the court and the people that were being appointed, and some notable firsts that happened while you were on the court.
Well, yes. With those four being older, the first to go was Whittle. He developed a condition, and went over to Johns Hopkins to have an operation, and he thought probably he wasn't going to make it, so he had made all the arrangements here to resign and so forth. He did make it, and I was sent by the court to go to Baltimore and talk him in to staying. But he never was well after that. He'd have occasion when he had fibrillations, and it would weary him, and he finally retired.
And do you remember who replaced him?
I guess that was Tom Gordon. Mm-hmm. Judge Spratley retired. I think he was sort of hoping that one day Eggleston would retire before him and he'd get to be Chief Justice for a little while, but that didn't happen.
I see. There was no mandatory retirement then, was
Judge
there?
Spratley was a very delightful old fellow. He really was. He could stand up in the middle of the floor and recite Shakespeare and poetry to and we used to tease him. He wore a green eye shade when he was on the bench, and claimed that the light hurt his eyes. Well, I didn't realize until I moved from the left side of the bench over to the right where he was, that what he used that thing for was when he wanted to take a little nap. He'd pull that sunvisor down over his eye.
And the lawyers didn't know he was napping.
Yeah. But I want to say, though, I was the youngest. They didn't know me. Now, Chief Justice Sneed and I were good friends because we both started out on the lowest court about the same time. We were both circuit court judges at the same time. But the rest of them just didn't know me. But I could not have been better received and better treated. There's a relationship that is just wonderful. It really is. Justice Buchanan wrote me just the nicest letter, and he says, "We often disagree, but our disagreements are never disagreeable." And that's held true. I think it's very important. I think it's very important. I think it's vital for an appellate court to produce an opinion which contains the composite views of the members of the court. And to do that, there has to be some give and take on positions. It's important that we avoid having a lot of dissents and concurring opinions. The purpose of the court is to establish what the people should govern themselves by, their businesses and their personal lives. And if we come back with an opinion that doesn't make it clear what the rule is, we've not done our job correctly. So the idea, the collegiality is important to getting that unanimity of opinion, which I think is so very, very important.
And what would you do in order to try to accomplish that if you had a particular case that you were maybe not necessarily in agreement with what the person who'd written the opinion said? Were there ways that you tried to work that out, rather short of writing a dissent?
Well, on occasions there'd be some part of an opinion with which you might disagree, that if you could get it changed, would make it unnecessary for you to dissent. And usually that is done. Now, if it's something that is the author thinks is absolutely essential to the opinion, that person probably would not agree. But if something can be changed that doesn't affect the opinion and its effectiveness, well, they could make that change and obviate a separate opinion.
So is that something that you would work toward when you were making decisions and when you were trying to come to a consensus?
Another thing that I'm very proud of, we are a very current court. Probably as current as any appellate court in the country. I'd get letters from other Chief Justices who found out about our situation, and one of them asked for a copy of our internal operating rules. What we had that made people get their opinions written on time, that he had one member who was 18 opinions behind. Well, I realized that we don't have any internal operating rules. Each member, as he or she comes on, is told that a case argued at this session, the opinion comes down at the next session. And that rule is followed, and we don't talk about it. That's what you understand. That's a part of it. Now, there are some times when that can't be done. Maybe the author can't get a majority, and it has to be reassigned. Even then, an effort will be made to get it ready to be handed down at the next session. But that's again, that collegiality, that cooperativeness that I think this court possesses, and is just as valuable as anything can be.
How, when you're doing that, how are cases assigned in terms of who's going to write the opinion, when the cases are decided? Because we see so much written about the U.S. Supreme Court about how they decide it and how the opinions are assigned, but there's very little known out there of how the Virginia Supreme Court does it.
Well, about 2 weeks before the court session, we draw some slips of paper out of a hat. And remember, it gets number 1, gets number 8, number 15, and so forth. It's a gamble.
I see.
I was never very lucky at gambling.
So that person is assigned to write the opinion, but what if that person is not in the majority of those who, when it comes to what the decision should be?
Well, that's where you may have to make change. But we have about 2 weeks before the session, as I say, and that gives the author an opportunity to look into the case, see if there's some procedural problems that need to be brought out during argument, or some questions that are not handled right the way they ought to be. But we then have our argument, and usually go to lunch after the session of court is over, then come back and start taking up the cases in the order in which they've been argued. The author conducts the conference, turns to the person on his or her right, how shall we decide the case, and he goes around and gets back to the author again. And as I say, if he or she says, I can't write it that way, the Chief Justice will ask, now, are you sure? Is it a matter, no, I can't write it that way. So then you've got to get somebody to trade with that person.
So approximately how many opinions would each justice write over the course of that 7 weeks?
4.
Mm-hmm. And I know that the Supreme Court currently has law clerks for each of the justices. Has that always been the case as long as you've been on the Supreme Court?
No, when I first came, we had none.
So you did your own research, too?
Hmm?
You did your own research?
Mm-hmm. But we talked about it, and the older ones were reluctant to do anything about it, and they didn't think the General Assembly would give us the money. And I said, well, have you asked for the money? Well, no. I said, how do you know they won't give it to you if you don't ask? Well, it was agreed we would ask. And sure enough, of course, we had to wait till the very last night that the General Assembly was in session. They gave us the money.
Do you remember when that was?
That would have been July of 1962.
Right. And so then you were able to hire, what, one law clerk per justice? And has that increased over the years?
They now have two.
Okay. And is there an extra law clerk for the Chief Justice, or?
Yeah.
In terms of the Supreme Court's caseload, over the years, going back to 1961 when there was no law clerks and up to now, has the caseload increased as the number of appeals filed, or the number of opinions a justice has had to write? Has that increased?
Well, I think that first year, in 1961, we had 420 petitions for appeal filed. We've been as high as 3,000. It's just not the increase in the numbers. It's an increase in the complexity of the cases and of the volume of the records that come up here. It used to be, it was unusual for a circuit court judge not to try a case in a day. Now it's unusual if any one of them ever does get a case tried in just one day.
Especially with a jury.
You know, the records go up and up and up, which means more reading for us and more detail. But of course, the our two-layer setup, where we decide whether we're going to grant an appeal or not, is different from the courts of many states, many states. And that's where a lot of hard work is done, getting those cases prepared for hearings, giving the lawyers who are seeking the appeal the opportunity to come in and tell us in person why we should grant them an appeal. We do that in panels of 3.
Somewhere I remember in my years of practice back in the 70s, you used to do them in conference rooms, sitting around a conference table. Is that correct? Or is that just my memory going back?
Yeah, we didn't have the hearing rooms up in the old building. We had the courtroom and we had the conference room. And we'd hear the, and some, for a while, the whole 7 would hear petitions for appeal in the afternoons if we got through in time. And we didn't break down into the panel thing until the caseload began growing and we needed to.
Do you remember when that was?
Oh, after I'd been on the court, maybe 8, 9, 10 years.
All right, so maybe the late 60s, early 70s, and that's when you broke into panels. And on the panels nowadays, you have both active justices and sometimes retired justices sitting on your panel.
We use 3 now, you see. And so we need the 2 active, two senior judges to make out 3 panels.
I see. So, but in prior years, had you only had 1 justice hearing writs, or was it always in panels of 3?
Well, when I came on, the practice was for the individual judge to hear petitions for appeal. And the lawyers would go to their home offices to do it. Justice Snee came up to my swearing in, took me aside at lunch, and he says, I'm going to ask Red Ianson if he'll come to Richmond. And if you'll agree to come to Richmond, the 3 of us will hear our cases and together and have it all done before court starts. Because the way it worked before, you hear your case individually, then you came down and you had to report to the court.
See, so you didn't make your decision on your own. You heard it and then reported back to the others. So that
So
was the beginning of the panels.
We agreed to do that. It upset Chief Justice Eggleston.
Why?
Well, if you suggested something that maybe was innovative, the answer to it was, we've always done it this way.
I see. So it was different.
And that seemed to settle things. I can remember when we began, the young members began lobbying to cut down on the time. And we got that, always done it this way. Well, they finally agreed on a compromise. We want to cut it to half an hour. They agreed on a compromise of 40 minutes. After about 6 months or so, one day, Chief Justice says, I've been thinking about this. He says, we're giving these lawyers 40 minutes to come in here. They don't need that. Let's cut it down to 30. Just as though nobody else had ever suggested doing it.
As long as it was his idea, it was a good one. And I wanted you to describe what those administrative responsibilities were when you first became Chief Justice in 1981 and how they may have changed over time.
Well, of course, it's just not administration of this court, but of the whole court system. And our executive secretary of staff consisted of two people, Hubert Bennett and his secretary. Now, Hubert Bennett, and I think he's still living, when it got around the state that the Supreme Court was thinking of getting someone to sort of overlook things, circuit court judges got all upset. What do you call it? The Super Snooper. They thought he was going to be getting his nose in their business.
Challenge their independence.
Well, Hubert knew how to play it right. He just did it the right way, and they didn't have that feeling. And for years, that set up, Hubert Bennett and the secretary was all that was needed. But then things began to grow and to change, and we got sort of worried whether Hubert could change too, but he managed to do it.
How long was he executive secretary?
I think from 1950 to into the late 70s.
All right. And the executive secretary position is really the chief court administrator for the it's called the Supreme Court Executive Secretary, but it really is a chief administrative officer for the judicial system, am I correct?
Right.
So not only responsibility for the Supreme Court, but the circuit courts, the general district, the
in
juvenile
practically every
courts.
other court
Exactly.
in the country, they call it court administrator.
Right. And since that office started with the one executive secretary and his secretary, how many were in the executive secretary's office when you retired from being Chief Justice?
Over 100. Well over 100.
Did the administrative responsibilities, besides just getting bigger, did it change over time in terms of what the Supreme Court did, what the executive secretary's office, I say the Supreme Court, I mean in its administrative role, did with respect to the judges and the judiciary of the Commonwealth?
Well, I think there was a decided increase of the involvement of the administrative staff with the courts. As automation came along, there was a big change in the relationship between the people out in the counties and cities and headquarters here. And automation has been made a terrific change in the operation.
What about things that you saw with respect to changes in the judiciary, changes in demographics? You started seeing, certainly on the Supreme Court, you were Chief Justice when the first African American was appointed to the Virginia Supreme Court and the first woman. Am I correct at that?
Yep.
So the judiciary and the other parts of the judiciary, the trial courts, were also similarly changing.
Well, there were things that we just adapted to, and things went, I thought, very smoothly. It was interesting to be in a situation where you're doing something for the first time. You're having someone for the first time. And I hope those who were the primary actors in it felt the same way. And it's broadened the vision of the court, I think, and brought us different viewpoints. That is a good thing. And the willingness to cooperate and to handle situations in the business-like way is just so vital to a proper operation of a court, in my opinion. I mean, we've got so much more work to do, and yet it seems to get done, and get done in a better way than before we got automation and all the things that help you now. But but the machines aren't any good without the people, and the attitude of the people being to cooperate in this thing. And I mean, that goes from the Chief Justice all the way down to the lowest person.
To the clerks out in the
sure.
district courts around the state. I
Sure.
agree.
It took us a while to get it. We started in 1968, and it became operational in 1985. That's 17 years.
Okay. And do you have any interesting stories of what it took to get that court created?
Should just keep plugging across the street.
Meaning at the General Assembly?
Yeah.
Was it an issue of money more than anything else?
Not so much. I think they did not see the need.
In terms of the caseload?
Mm-hmm.
And that was back when the General Assembly was dominated by lawyers. Mm-hmm. Unlike today, when there are many fewer lawyers in the General Assembly. So what did you do as Chief Justice to get them to understand it?
Keep going over it year after year and talking about it. Had to do with any number of problems. Something that is new, not always attractive, just because it is new, and it just takes persistence to get them to see that it's needed. The same thing was true of the family court. But that worked so well. We got authority from the General Assembly to set up those pilot courts. And they were just absolutely successful. And everyone agreed that they had showed that there was a need, and that was the way of fulfilling the need. And but that took several years to get it to the point that we lost out in the end. But
well, let's go back, because I know the family court is very important to you. For the record, what did you see? What was the reason that you and others felt that a family court was important, and how was it going to be created?
Well, as you well know, jurisdiction over family matters are split. Circuit courts have certain parts of it. Juvenile domestic relations case have parts of it. You have an appeal of right from the juvenile domestic relations case to the circuit courts. And too often you have cases, the yo-yo effect. Appeal to the circuit court send them back to the JNDR courts. And that just go on, you know, to where people just didn't know where they were at. Especially in the JNDR cases, we need judges, specialists in the types of matters that they're handling. And that is true for some of the cases in the circuit court as well. It's just the idea that the cases involving that area of human relations ought to be in one place with trained judges handling them. And it would have meant adding more JNDR judges, of course, but it would also mean we would not have to keep adding so many more new circuit court judges when the jurisdiction over the domestic relations matters removed. Now, I knew and I could understand that there were some circuit court judges that didn't want to see that change made, didn't want to give up that jurisdiction. But on the whole, I think we sold the idea of the family court as a solution to our problems. And its day will come.
I think the point that was well made by you in all the times, all the support you made of the family court was the fact that you had one court where all the family issues could be addressed, and that there wouldn't be, as you said, the yo-yo effect of going back and forth between two courts. So you'd have a swiftness of adjudication, you'd have a certainty of adjudication, and you'd also have one judge who would not only hopefully be a specialist interested in this area of the law, but also someone who could make the decision, who would know what the family dynamics and issues were. If I would ask you, of all the things that you wanted to do in your years, in your career, what your biggest disappointment was, would I say that the fact that there is no family court in existence right now, would that be correct?
I think so, yeah.
But in other things that you worked on that did happen, can you think of some of those significant accomplishments?
Well, I'm very proud of our Virginia State Bar mandatory course on professionalism. As you know, Bill Dolan was president of the State Bar when we got the idea. He and I worked on that together. And I was very apprehensive about it. I mean, here these young people are, they've gone through, they run the gamut of getting their college education, gotten out of law school, they passed the bar, most of them gotten good jobs, they're all set to go. We said, not yet. You got to give us 2 days of your time and $125 your money and come listen to these speakers. We had the first one in a hotel at Crystal City, December 18th, 1988. And I say I was very apprehensive. I was going to make my speech after lunch. Well, Bill Dolan was waiting for me, and as I approached the hotel, I saw him through the door. And I got close enough, I said, everything's all right. He was grinning. And indeed, things were. He snuck me into one of the sessions, and it was a lively discussion and so forth. But I think one of the nice things that happened, I was able to get Lewis Powell to come over to the luncheon. He wouldn't agree to say anything, though.
Justice of the U.S. Supreme Court from Richmond.
And I think it was because he thought that might take away from me. I said, well, I'm going to introduce you. Well, I did, and those young people just stood up and gave him a wonderful standing ovation. And it moved him. He told me after he was surprised. I said, well, Louis, you don't realize the esteem and respect these people have for you. But I think his being there just established the level of what this course was going to be, and has kept it till this day.
It was visionary because I don't think many states were doing that. I'm not sure if they are now. But
Last I heard, there were about 15 that had followed our example. You have no way of knowing whether it's doing any good or not. And I did over 100 of those speeches, I'm told. I always came away from every one of them with a feeling of satisfaction that we are doing something, and maybe it is doing some good.
I think it is. I think it is. I'm hoping that some of the law schools will pick up and bring it even when earlier on than when they're actually on their way to get their jobs, because I don't think that we can emphasize enough what the standards that you set, that Justice Powell set, of professionalism for lawyers. I don't think we can ever overemphasize it. I think it's always got to be there. It's part of.
And you've got to keep reminding them of it too.
Exactly.
Yep.
Exactly. But you did some other things that were started when you were Chief Justice. So sentencing guidelines in felony cases in circuit court.
Well, that was another one of those things. If you had taken a vote on whether the judges would want those, it had been 99 to 1. It was to say, if you had voted without those meetings, it would have been lost completely. As it was, I think there was one region that was not unanimous in the whole state.
And this was at the same time when the federal government was imposing guidelines on the federal courts, correct?
Theirs came a little later. But it's just, on this efforts I try to make to get lawyers to do pro bono work, some states have put in mandatory pro bono programs. And I hope we don't have to come to that, because it seems to me that pro bono assistance given out of a spirit of compassion and of you wanting to be of service to someone is going to be more meaningful and more effective than if you're doing it because it's been shoved down your throat.
And you worked with the Virginia State Bar to do things to basically urge lawyers to do pro bono work, to give them incentives to do it, to honor those
Yep.
who gave time and effort to pro bono work, and that's still being done today.
Still am.
And in addition, there were jury management. Wasn't there some efforts made in terms of managing juries and making jury service more effective and efficient throughout the state that started when you were?
Mm-hmm. Yep. Trying to make their stay more pleasant and more understandable.
And let's see, another thing I think I made a note of was the alternative dispute resolution.
What?
Efforts regarding alternative dispute resolution,
Yep.
mediation and arbitration,
Good.
and those things. Those efforts were all begun while you were Chief Justice. Yep. And drug courts too, drug treatment courts.
Yep.
Drug courts for some for adult offenders, some for juvenile offenders. They're in effect in some courts around the state.
Yep.
So it was a large number of accomplishments for your tenure, and so many others that I didn't even make note of. But in addition to your work at the level of the Commonwealth, both on the court and with the trial courts around the state, were you involved in any national organizations or efforts?
Well, yes. With the Conference of Chief Justices, I I was president of that in 1989, 1990. Chairman of the board of the National Center for State Courts, which was a Chief Justice Berger child, you know.
Oh, I didn't. Tell us about the National Center for State Courts, how it was born and what it does.
We had a national conference of judiciary here. President Nixon came, and Chief Justice Berger came. And in his ending speech, he said we should not leave Williamsburg without creating a National Center for State Courts. The federal judges have the Federal Judicial Center to assist them in the research and this, that, and the other. The states don't have that. The National Center for State Courts went operational within 1 year.
That's amazing.
It was amazing.
That's amazing, and that's in Williamsburg.
Yeah. Well, when it first started, it was in Denver, Colorado. And there's some efforts to get it in different places. And we sort of decided we think it ought to be here. We got Linwood Holden to agree to raise $100,000.
When he was governor?
He was governor. And he did. Not of tax money, donations. And that's what sort of swung. And I think Berger wanted it closer to him.
Closer to Washington.
Yeah. But it's a great help. It really is.
What does it do now? What kind of work does it do with this, for the state courts now?
Well, if you have some change you want to make and you need advice and assistance doing, they've got the experts down there to do it. Docket control, all the features of court administration. They have good people in, top people.
And they can provide resources that can help advise you or state courts around the country on those issues that are relevant to whether court security, docket control, case management, things of that nature.
Yep.
And you were the head of that too when it came to Virginia. You were the head of that of the National Center.
No, I was the same year was. If you're elected president of the Conference of Chief Justice, that same year you're chairman of the National Center for State Courts.
I see. So on top of all those things you were doing, and all the administrative responsibilities that you had, you obviously had to still hear and decide the cases here at the court as well. How did you manage that? What was your typical day?
Well, I was here at 7:15 every morning, and I got my work done between 7:15 and 9. I did all the rest of the day.
Because no one was here.
Yeah, but I'd be here 6:30 or 7 at night, and once I got a computer at home, I worked all weekend on a computer at home. That's where I write my opinions.
So you do it at home rather than doing it during the day while you were here.
Yeah, because I don't get interrupted at home.
I see. And on how much traveling did your job involve when you were Chief Justice?
A lot. I'd go. Most anybody want me to come make a speech, or go to the judicial conferences, and then I made very many trips the year I was president-elect of the Conference of Chief Justices, and the year that I was active, to go to different states to make speeches.
In addition, obviously, you had a very full day every day working here at the court, doing the other administrative responsibilities, working on national endeavors. How did you relax? What did you do for relaxation when you weren't writing opinions or making speeches or running the court?
Yeah, I'd ride my bicycle every morning.
How far? Was that before you got here at 6:30?
Yeah. I'd get up at 4:15.
And ride your bike for how far?
45 minutes. Or rollerblade.
Or rollerblade. And this is not, you're talking about the recent past, not when you were Much younger, correct? You were out riding bicycles, when you were at our judicial conferences several years ago.
Yeah. Yeah,
So-
we used to have sort of a club.
That's right, and it was my colleague Judge Kendrick who
Yeah.
taught you how to rollerblade,
Yeah.
right? So and you've done that up until fairly recently, the rollerblading,
It's been several years.
when they closed your favorite park.
Yeah.
Have you noticed, in having the opportunity to look at the Virginia Supreme Court from 1961 until today, have you noticed changes in the dynamics of the court over time?
I don't think so. I mean, life itself is much more dynamic than it was in 1961.
The types of cases, let's look at criminal cases, because obviously the standard, there's always going to be criminal cases that come, unfortunately, through the courts. Do you notice a change in the types of criminal cases or the nature
We
of the
got sexual predators now. We never had those before. Yeah, there've been that sort of thing, but somehow we have a wonderful ability to adapt and to absorb those changes and to conform to them.
Are the cases, do you think, more challenging now? You said they were longer and more complex, just the records themselves. But do you think they're more challenging in terms of the
Probably
issues?
so, yes. Yes. Probably so.
And you think that's partially due to the change in the complexity of our society?
Mm-hmm.
And increased diversity in our society as well?
Mm-hmm.
What have you noticed in terms of, one of the things that's changed, obviously, in the years that you've been a judge, is the increase in the number of people that come into Virginia now, come into our courts that speak a different language, don't speak English as their first language. How has that impacted on the appellate jurisdiction? I know how it happens in trial courts, but how about an appellate jurisdiction? What does that do
I
to
would
the
say
appellate
it's
cases?
been minimal. It's been minimal.
The translation services are working well, and so the records you're getting are clear.
It's just not a real problem. Mm-hmm.
You said earlier that, speaking of Chief Justice Eggleston and others, that when you came on the court, it was very difficult to get things changed. This is the way we've always done it, and we're not going to change. It's always worked. Do you think as time went by, people were less bound by that and therefore tried new things at
Oh,
oral
yeah.
argument?
Yeah. Mm-hmm. Yeah. It took a while. It took a while. It took some changes in the court. And the old timers, I mean, they were serious said we've always done it this way. They meant by that we're going to try to keep on doing it this way. But now, I must say, I don't want to detract from the greatness of them. It was a wonderful experience to be associated with them. It's been a wonderful experience to be associated with the members of my court all these years. I just don't know how to say it.
I think your feelings, your emotions about that are very clear. That each person who served on this court, each person that served with you, has contributed in some way and built, and contributed in a positive way toward building the court to what it is today and to what it will be in the future.
That's right.
That's how I understand.
That's right.
Now that you're a senior justice, you're not fully retired sitting at home. You're still working, right?
Right.
How often do you sit?
Well, I come to office every day. And the work related to whether we're going to adopt an appeal or not is still the same.
So you're still regularly hearing
except
writ
it's
panels.
increasing. Just this morning I get handed to me 40 memos
On writs?
that I have to read ahead of time of a presentation on Thursday. Ordinarily, we wait and hear the staff tell us about that. But the work's just too much. We got to read these 40 memos ahead of time.
And this is for a writ panel on Thursday?
Yeah. But,
so if anything, it's even more work now.
Yeah. And then I still write an opinion each session and do anything else I can to help. And I also, they made me a professor of law at the University of Richmond. And I spent some time out there that is very interesting.
What are you speaking about at Richmond?
Well, the dean sort of let me write my own ticket. I was warned by one of my associates not to agree to do anything where you have to grade papers. So I make a series of lectures, one on pro bono, one on John Marshall, one on the traditions that we ought to get back to. The last Friday it was on professionalism. They have a course out there, professional responsibility, and I do that once a year. And then I hold office hours, usually on Thursday afternoon, for students to come and talk to me. And that's the best part of it.
That must be. That must be. You probably have a waiting line down the hallway outside your office of people to come meet with you.
Yeah, I went out there Thursday. I was going to hold office hours, not for 2 hours, but for 1 hour. And then the second hour I was going to be making this presentation to the class on professional responsibility. Well, I get there, 12 of them are up in my office wanting to talk. But you know, they're so sharp and bright. And then they ask questions that sometimes you really have to be careful.
Careful what you tell them. Well, and so what you're doing is what we talked about earlier about the professionalism course being good, the course that we require all the lawyers to take in their first year of practice in Virginia. But what you're doing now is basically taking that and taking it back to the law school, so it's not just something they're hearing for the first time when they're first in practice.
Yeah.
But
well, I think all the law schools are doing that now. Yeah.
And is that a required course at Richmond? Or
No.
Is it, okay. Maybe that'll be the next step,
Yeah.
that they require the lawyers to take that.
Yeah.
But so you're certainly not resting on your laurels at this point.
I don't know how it would be like to have nothing to do.
Oh, yeah,
you know?
There's not enough hours in the day, it sounds like. And you still do traveling? You're still traveling?
Well, we're doing some, yeah. My wife is very busy in her job, but
So you find some time, though, to get away? Have you gone to England lately? I know you love to go to England.
we haven't been to England since her father died. Well, we went over after he died, dropped some ashes in the Thames, but we haven't been back since. And but we go to the Chief Justice's conference every year. I can go as a past president. Otherwise, I have to ask my Chief Justice if I can go.
I see.
And he wants me to go, so there's no problem there.
Oh, that's good.
But
So you still keep in touch with the Chief Justice's conference as well?
yeah.
Can you think of anyone, either when you were a judge in Fairfax or on the Supreme Court, who you'd say, now that guy was a true character?
Yeah, and it's true. Fairfax, even with a small bar, all of them were characters, you know. They had their own way of doing things. There was old Senator Walter Oliver. He wore spats and a gray vest and a blue coat all the time. And he'd just get up and he thought he was a pretty good orator. And
Was he?
Well, I didn't. I don't like people shouting when they're supposed to be speaking, you know. And I worked for Center Rust. The last 2 years I was in school, and he was a character. He and his son was there part of the time I was there. The son later went in the service. But Mr. Rustin had a series of young men. One of them stole from him. And he says the guy stole $3,500. Others tell me it was a whole lot more money than that. He just didn't want to admit it had. And the guy stole it because he married the best looking gal in town, and she was used to living high, and it took more money than Mr. Russ was paying this guy. But when we get a title in, we check to see if the office had done it before. And it would depend upon what person had done the title to whether we would use that file or start out over again.
Talking about the land records, real estate title.
And it infuriated old Senator Russ when we wouldn't use one of the files. Well, one of them we would never use was this guy that stole from him. And Mr. Russ jumped on us. He said that was the best guy I ever had in here.
He was a thief, but he's a good worker.
That's right.
Do you have any sort of concluding thoughts? You've shared so much with us in terms of your thoughts and your experiences and the history of you and the Supreme Court. Do you have any final thoughts or reminiscences about the Virginia Supreme Court that you want to leave us with and leave with those who are going to be searching, looking at this sometime in the future?
Well, you know, I just happen to think we have a wonderful state. I think we have a wonderful bar. I think we have a wonderful judiciary. I'm proud of all three of those things. I've done a lot of traveling, as we suggested, and I'd go into states and see how things were done. Always glad when I got home. I remember the ABA got some money from LEAA.
LEAA, right.
Yeah,
Law
Enforcement Assistance Administration, to put on a national conference on appellate standards. And Albertus Harrison and George Cochran and I went down there. And we go into a session, the BWS come out, we look at the HGS and say, we've been doing that for 20 years. And when time came to come on, they said, now, you can make application to LEAA to hire consultants, come in, make a comparison between the ABA standards, your rules, and your statutes, and determine what you need to change. Well, we got the grant. Hired the National Center of the State Courts to do the study. It was a waste of money. There was so little that we had to change. I just think we've got something here that is very special. Some integrity still means something. And it's something to be proud of and fight to preserve and to keep it strong.
How do you want to be remembered?
Well, I hate to say anything, but I'll be accused of patting my own self on the back.
I don't think anyone would ever accuse you of that.
Well, maybe they'll say that he tried to do a good job.
Well, I think,
and let it go at that.
in my opinion, I guess I get to give my opinion because I think not only did he try, but he succeeded.
Oh, thank you.
In very many fold. Thank you very much, Justice Carrico, for taking your time and sitting and answering these questions for us today. And it's certainly going to be a marvelous addition to the Supreme Court historical records. Very important history of the time that you spent on the court and the work you did for the court. Thank you very much.
Thank you.